Good afternoon, ladies and gentlemen. Let's begin. Welcome to the session on understanding the limits and benefits of data portability. My name is Thomas Zerdick, head of the IT policy unit in the European Data Protection Supervisor. And what is data portability? Sure, we all know what number portability is. That's something we in Europe knew since 2002, since the Universal Service Directive. But personal data portability really can only be traced back as an EU concept to 2010, where the European Commission published a communication on the comprehensive approach on personal data protection in Europe. And in that communication, the Commission promised to examine ways of complementing the rights of data subjects by ensuring data portability, which is providing the explicit right for an individual to withdraw his or her own data, for example, his or her photos or a list of friends, from an application or service so that the withdrawn data can be transferred into another application or service as far as technically feasible without hindrance from data controllers. Now, as you can see, that more or less already corresponds to the new data portability right, which we know from Article 20 of the General Data Protection Regulation, which we have since 2016 and which applies since roughly 8 months. Yet, today in 2019, we all still have questions on the practical application of this data protection right, of this new right, such as, can we use apps to port the data? What are today's technological constraints, et cetera, and I'm very happy that I see you in such big numbers, and we can discuss all of these questions today with the panelists and with you, hopefully, in the audience. Let me introduce to you the panelists. I'll start with Gabriela Zanfir-Fortuna, Policy Counsel for the Future of Privacy Forum and leading the EU policy work in that think tank and author writing on data protection law. On my very left is Olivier Micol, who is head of unit of the data protection unit in the European Commission and Director General Justice and Consumers. Then we also have Babak Jahromi, who is working on solutions to global technology policy challenges for Microsoft and is working in that capacity on international standards, open source solutions, or other similar global venues. And then we have Joris van Hoboken, who is Professor of Law at the Vrije Universiteit Brussel and a senior researcher at the University of Amsterdam. And of course, a panel wouldn't be complete without a moderator. Stacey Gray, Policy Counsel at the Forum, at the Future of Privacy Forum, focusing on US legislation and public policy around data protection, with a focus on privacy implications on online and mobile advertising, consumer electronics, and the Internet of Things. Now, as is traditional now on panels like this, we'll hear a few opening statements with a debate, and then you come in. So thank you for your interest from my part, and Stacey, port it away, please.
Thank you so much, Thomas, and it's really a pleasure to be here with so many experts on this panel, and so I will keep my remarks very brief and get as much as possible to the debate on this panel and to your questions. As Thomas mentioned, in the United States, as I'm sure you know, the major focus right now in Washington, D.C. is whether we will pass a federal comprehensive baseline privacy law, as FPF and many others have called for some years. This is a source of debate in Washington, D.C., of course, that was inspired largely by the events of the past year. It came onto the political scene largely because of the events of Cambridge Analytica accessing data from Facebook. And of course, all of you are very familiar with that case from earlier in the year. We don't need to recap it. I'll just say that, of course, the biggest issue there was consent of the users to share data with a third-party app. But other issues at play, we believe, have some overlaps and parallels with the issues that we're going to be describing here today, like what is the role of a platform in having oversight and accountability of the other controllers that it permits access to its data, right? As we work through that at the federal level, Gabriela will tell you about how data portability has also become a part of state legislation in the last few years. State legislation in the United States, of course, is driving much of the federal policy debate. And so 2019, really more than any other time, is the time to be figuring out the challenges here, the limitations of data portability, the benefits of anonymizing and de-identifying data in a way that might hinder data portability, and we'll talk about all of that. First, Gabriela, my colleague from Future Privacy Forum. Gabriela is going to tell a story of how this came up in the United States and other contexts over the last decades, where it is today, and set the stage a little bit for our conversation.
Thank you very much, Stacey, and hello everyone. Thank you very much for being here with us in the afternoon of a third day of a long conference. We really appreciate it. So my secret plan for today was to let you know that data portability is not an exclusively European issue. In fact, the first ideas around this, the first debates in the public sphere, and is particularly with regard to research and with a particular focus actually on competition, appeared in the United States. So that's why I was thinking that it would be good to talk a bit about the context of how the discussion on data portability appeared in this space. And to start, I will briefly describe the facts of a case that dates from 2000 in the US. It's a case, reverseauction.com versus the Federal Trade Commission. And it was generated because reverseauction.com was a player that wanted to enter the market of e-commerce. And they wanted to be a competitor of eBay. They thought that the best idea to do that is to actually get all the data of eBay's users, their username, their emails, but also, very importantly, the trustworthiness ratings that the sellers or buyers actually from eBay had. Because if you would be a serious buyer, you would always pay for whatever you auctioned on eBay. That meant that you would aim to have 5 stars, which helped with your future transactions. And reverseauction.com thought it would be great that in order to get these new users, the users from eBay can come on their platform with their trustworthiness rating. With their reputation, their good reputation. They were significantly slapped, let's say, by the FTC in a very interesting decision, if you have the time to look over it. They were sanctioned for violating privacy, and in particular Section 5 on fairness in the FTC work. And however, in that decision, the FTC recognizes that there was a way, so there was also the recognition of the way in which eBay's control over user reputations, the accumulated result of so many transactions, because the reputations were built over time, blocked competition in online auctions. And this is a case, I told you, that dates from 2000, so about 20 years ago. Data portability is not new in the European Union context either. because we have the Universal Service Directive, which was adopted in 2002, and I think it was supposed to be applied in 2003. So again, a long time ago. And this directive actually provided the right to portability of your telephone numbers. And I'm sure many of you that live in the European Union benefited from the right to port your phone number from one service provider to the other. And what I found interesting is that in the recital announcing this article and explaining it, we have there the fact that portability, number portability, is a key facilitator of consumer choice and effective competition in a competitive telecommunications environment. Now, fast forward 10 years, just as Thomas told us earlier, in 2010, the Commission started to think about data portability as a right that is very much connected to data protection rights of individuals here in the EU. And it happened more or less in the middle of my PhD thesis writing. So in 2012, I was writing a thesis on the rights of the data subject, right? And we had the set of rights of the data subjects in Chapter 3 of Directive 95, but then we see the proposal of the GDPR, and I read it, and all of a sudden, a new right pops up. So I had to, go back to the books and study a bit about what is this right to data portability. And this is how I became interested in it, and this is how I discovered that at that point in time, there was much more literature in the United States than in Europe on data portability related to the online environment. And to present day, the right to data portability proposed by the Commission in 2012 became reality. We now have it in the GDPR under Article 20. I'm not going to go into the details of the provision right now, but I would just like to add that, in my opinion, this is the only true new right of the data subject that was introduced by the GDPR compared to the previous legal framework. And in my opinion, it is meant to be primarily, indeed, a right of the data subject in the sense of providing control of the individual over their personal data, but it is also very much an enabler of competition. It has limitations, and I'm sure we will discuss about details, when we can use it, when we cannot use it, because it has limitations with regard to the lawful basis for processing and other limitations. But before giving the floor to my colleagues, I just wanted to also use a very fun slide after all those quotations and let you know that the right to data portability is spreading right now. And this is a photo from California. And that is because in California, a new Consumer Privacy Act was passed this year, actually, and it will become applicable in January 2020. And a very nice surprise to me was that this California Consumer Privacy Act actually provides for a right of access that automatically entails a dimension of portability. Because it says that whenever access is provided electronically, the information to which access is being given to shall be in a portable and, to the extent technically feasible, in a readily usable format, right? So we see that the right to data portability moves on. And this is, I think its aim is supposed to break the lock-in that we have on the online market right now. Thank you.
Excellent. Thank you, Gabriela. One thing Gabriela didn't mention but was very relevant towards the beginning of your presentation is that the Federal Trade Commission in the United States is in fact primarily a competition body. The FTC is a civil enforcement agency that was founded over 100 years ago to regulate unfair and deceptive business practices. So it's primarily a competition authority, and only maybe in the last 15 years has it entered the privacy space. So, Olivier, why don't we hear next about the views of the European Commission? Is the right to data portability primarily a right of the individual, an enabler of competition, a dual purpose provision?
Thank you very much, and thank you indeed for being here on a Friday evening or afternoon. So, indeed, I mean, I would take your first assumption, that is to say that indeed portability in the GDPR is first and foremost an individual right. But there is a lot of discussion ongoing, especially these days where we're discussing about platform, about free flow of data, etc. And there is sometimes a bit of a mixed up with having, let's say, some companies having access to the data stored on platform or by intermediaries. And we still use this portability word in order to describe this access by other companies. Under the GDPR, the portability is indeed a right from the individual, a request from an individual to a certain data controller to basically, as a complement to the right of access, building on the right of access, but with a more limited scope to have this data, to receive the data, and when technically feasible, to port this data to another data controller at the request of the individual. So I think it's very important also to keep in mind the condition framing the data portability, because it applies only when the data are processed by the data controller, by the company, by the platform, based on the consent of the individual concerned or based on the contract. So, for instance, a bank who has a legal obligation to process certain type of data, then normally the right to portability would not apply. It can be that the bank voluntarily would go beyond its obligation, but really the two, the data have to be processed legally under consent or the contract. It has to be processed through automated means as well, which is the cases in most instances that we are concerned with. What is very important, and which is probably the subject of the most of the debate, is the fact that the data have to be provided by the data subject. And this is where, I mean, the interpretation of the scope of portability leads to very interesting discussion, because there are some situations where we all fully agree about what is data provided. If I upload photos, if I dial a telephone number, if I, upload materials on a social network, this is really provided by me. Everybody will agree with that. Then the question is, and you find that, for instance, in the very interesting guidelines developed by the European Data Protection Board, grouping all EU data protection authorities. They have a guideline on data portability, which I strongly encourage to read on a Sunday evening, for instance, in 2 days' time. And there it is said, indeed, that the data observed from the activities by virtue of the use of the service or the device is among the data provided by. So where do you put the cursor? Because indeed, if you have a smart meter for energy, for electricity in your home, indeed, this is the data that we consider is provided by. You are not inputting, let's say, uploading data, but this is really your activities. This is you as a human being. You switch on, switch off your electricity. This is a data provided by. Or you put these wearable devices to measure your heartbeat, etc. It's a data you are provided in order to get a service. Where it gets a bit more complicated is then when you have data which are byproduct of services and which are not necessarily raw data, but they are basically, I mean, the data controller would use an algorithm and would infer a number of data and would build enriched data. And then would be out of the scope of the data portability. And this is very important for in the cases that were mentioned before. When you put, you have a telecommunication company or you have a bank, okay, all your operations, they are indeed provided. Your profile as a good client, this is something which has been inferred from the data you have provided, and then it will fall out of the scope of the portability. But there might be many cases where this delineation has to be assessed really strongly on a case-by-case basis, and it is very important also to protect trade secrets and intellectual property. Now, how is this right being applied in the last months? Well, I mean, in the Commission, we have a multi-stakeholder group with a representative of the industry and civil society, and until now, there is not so many cases, in fact, so many requests for data portability. We are still in an early stage. We know that a number of industries are working together also to make this right work, because the data have to be provided in a machine-readable format. But what does it mean in practice when you download your data and you receive basically a big files in format which theoretically allows you to reuse it? But if you have a completely different interface for a service that you would like to use, this makes the portability, in effect, relatively difficult. And we know that for instance, a number of telecommunication companies are working jointly in order to allow this working together on a common format, which is strongly encouraged by the GDPR. And I would like also to concur with what had just been said, that there are several sectors where such portability under the GDPR come on top of sectoral portability. This is what you have, for instance, in the Payment Account Directive, where when you want to move your bank account from one bank to the other, there is this EU legislation which it's called switching. In fact, it's not called portability in this case, but it has the same idea of indeed supporting a consumer moving to another organization. In this case, it's very much consumer competition, while, as I said, under GDPR is a fundamental right. So they complement each other, but they are not exactly the same. And I think I will stop here because I was too long. Okay, good.
Excellent, thank you so much. We're going to now turn a little bit to the concrete on-the-ground practice of data portability. So in June, I believe, of 2018, July 2018, Microsoft, Facebook, Google, and Twitter introduced the Data Transfer Project, an open source initiative. And Babak, tell us about that and how it's been going.
Great, thank you for the opportunity. Let me start with a bit about the technical aspects and requirements of data portability. First is that data portability is hard. It's much harder than you may think. Let me quote from a recently published international standards on the topic, ISO IEC 19941, that is freely available. You can all welcome to download it. This standard defines 3 technical facets to make data portability a reality. First one is syntactic, which is the obvious one. Is the data a 16-bit integer, or is it a string, or is it a floating point, or whatever? That's, of course, that has to be understood in terms of technically, in terms of having a machine-readable format. So that's easy to understand. But the next level of requirement for data portability is semantic interoperability or portability, or the semantic mutual understanding. And by that I mean, let's say the piece of data says Jaguar. The sender and receiver need to agree or understand that the word Jaguar, is it a member of the cat family or a fancy luxury car it's now owned by, I don't know, I forgot who bought it, but it's a British fancy car company. So the semantic is actually very important, and you will find that a lot of when portability fails, it's not because of syntactic, but it's actually because of the semantic problems that exist. And then last but not least, the third facet to make data portability a reality is to make sure that the policy facets are are met, meaning the regulations and contractual requirements and agreements from the source and the sender, and from the sender and receiver are indeed compatible. For example, geolocation, agreements on data sharing, mutual responsibility for access and security and privacy of data. So these three facets are important for to actually technically making data portability a reality. So now, having said that, we're now in an era where data portability alone is not enough. We need to have, what we're being asked to do is to provide automated transfer of data, and this is part of Article 20, when technically feasible, of course. And that puts it, I call that data portability on a steroid. It pushes the envelope one level beyond and makes it even more interesting challenge. To make all this a reality, one solution that industry has come up with, some industry members have come up with, is this project that Stacey mentioned, the data transfer project, which is an open source project, free for everyone to join and participate, and I'll be talking about that. But just very quickly, it's an open source project in GitHub, licenses Apache 2.0, and the current code base is Java based. And we have 4 official publicly announced members, Google, Facebook, Twitter, and Microsoft. They have other members who are participating, but they haven't announced yet. We have weekly technical conference calls, bi-weekly high-level coordination meetings. And the project has been going, as Stacey said, was announced since July. So let me talk about some of its founding principles. One is to, all the members agree that we all want to work on it collaboratively to make the direct transfer of data possible when it's really technically feasible. There are cases where it's feasible, there are cases where it's not. And we all acknowledge the fact that the number of direct transfer data scenarios is very large. In fact, I'll have a slide about this. It shows it could be exponentially large number of scenarios, and it's a very complex process. And third, but last but not least, an open engagement, an open source project, we believe is the best way to do. And I'll explain later why that is the case. So some examples about, obvious examples about data transfer requirement, or examples for it. We all have photos, files, contact lists in our smartphones, calendar information, and of course, our emails. Those are great examples of, as Olivier said, these are information that we as users have provided to the online service providers, and of course, we have the right to ask him back. I mentioned that about the exponential number of cases. Think about this is a bit of your high school math, if you remember. If there are n online service providers that are supposed to provide, to engage in direct transfer of data, the number of actual pairing of the transfers is an n square problem. So the more the number of providers, the higher, in fact, it's an exponentially growing number. And that by itself shows the complexity of making this a reality. So because of all this, well, let me also mention that there is really GDPR and other portability regimes, requirements, they all mention, most, including California, recent California privacy law, they mention their technical feasibility of it, when technically feasible. And the question is, who decides and how do we know a given scenario is technically feasible and one is not? And we believe that the only way to really know is through an open process, using open technologies in open source model, and through a robust participation. That's the only way the community can, in large, can decide, can determine for itself if a given scenario is feasible or not. There's no one company or no one person or one government can really would be able to determine that. So it requires an open process. So let me explain a bit about this project and how it works. Because of, obviously, as was mentioned by other panelists, the controllers are not they can't make a decision about the transfer. The idea or the need or the request has to come from the user. So obviously the user has to initiate that. And then once the users initiate that through some user interface, the providers will have to work together. They will have to have built a system that through open engagement that make that transfer a reality. Examples are, as was mentioned, telecom carriers, for example, have location data. That's obviously valuable information that users may want to extract for other purposes that they have in mind. This is a very high level, very coarse-grained architectural model for this open source project. The gray box is the common runtime. It's the most often a cloud-based workload that runs the whole automated transfer. The blue eggs on either side, it's a pairing of adapter code that two online service providers that want to participate in a direct transfer scenario, each of those, the sender and receiver will have to do their share by writing an adapter that extracts the data in the case of the sender and uploads the data in the case of the receiver. And the adapters have well-known interfaces and they run inside this runtime. And the runtime takes care of the management of the whole process. The transfer needs to be curated because in some cases the data could be very large. So you could ask for it tonight, and 100 megabyte of email the transfer will be finally complete the next morning. So there has to be user interface and background processes and engineering tasks to curate this potentially long, erroneous process. And I have some other slides in the back at the end in the appendix that can explain it, but I won't go in more detail, but I'm happy to answer any questions after. How am I doing in time?
Perfect.
Okay, almost done. So what is unique about this approach to realization of the potential of the direct transfer of data is that each pair of a source and destination, for each pair there has to be a open source adapter pair that I mentioned. The source vendor checks it into GitHub through enabling a test scenario where it shows that the adapter they checked in is able to extract the data. A potential receiver would use the sender's adapter and write their own uploading adapter to pair the two. And then, as I mentioned, there's a common runtime that is built with a lot of good hard work from several engineers from these companies that does the task of the actual transfer and runs it in the cloud as a cloud workload. And the important thing is that we all have to remember that good privacy can only be a reality when it's built on top of good security. And a lot of energy has gone into this code base to make sure that it's highly secure, because otherwise we'll be opening the biggest data breach possibility in history. So this is very, very serious, and the member companies have gone a long distance and invested a lot of resources to make sure that this is a highly secure environment. Some of the details, as I mentioned, the pairing has to happen. Each member writes their own adapter. There has to be the runtime has to be hosted somewhere for the individual transfer. Oh, I forgot to, sorry, thank you. And so what we need at this point is we have a lot of scenarios enabled already, as I mentioned, email, calendar, contacts. We're working on some additional scenarios. But for this project to really be successful, it's just not enough to have a few big companies engaged. We need to have a broader participation. So think of it, so take this from me as an appeal for other companies, especially mid-size and smaller companies, to join this effort, because without them, I don't think we can call this a success. Thank you very much.
Thank you, Babak. And Joris, just to return it to kind of how I opened a moment ago around how Cambridge Analytica has spurred so much of the privacy debate recently in the United States. We're aware that platforms are becoming major facilitators of both privacy and data portability. Do they have special obligations? What is their role in this? I turn to you.
Thank you. There are my slides. So, yeah, I wanted to maybe just kind of take a step back and present some ongoing work that I'm involved in, that I'm leading. And so, I think obviously data portability is one of the examples in which data protection has really gained a strong focus on effectuating control over personal data, and even like for people to be able to gain the value out of the data, their personal data, or part of their personal data. So I just wanted to maybe start with a general remark about what it means to think in terms of control. And I think in a classic environment where information systems were relatively standalone, data was collected about people, stored in databases related to those particular like functionalities that the system was provided. We lived in a bit more simple situation also to think about these data protection issues in terms of control. But I think the complication nowadays is being that we see a like heavily networked and a system of services, you know, all these types of ecosystems and information flows that have a very networked nature, where the question is really who is going to take responsibility for what aspect of data protection and ensuring data subject rights. And on the other hand, I think something that's often overlooked, but also I think quite relevant in the context of data portability, is that a lot of personal data has a very social nature. You know, it's like you're porting pictures that's going to have data of other people on those pictures. You know, so, or you're porting your conversations. Maybe I want to port my Signal conversations to service that is not that privacy friendly, and actually the people I'm having conversations on Signal with, they may not like the fact that the data is suddenly going somewhere else. So I think there, for me, that is a bit of a starting point for some of the thinking that I'm doing in this space, that there are a lot of complications if you think about really about data protection in terms of control. So, and then maybe secondly, I think what you see and that I want to focus on in my presentation is that platforms have really emerged as really key players in shaping and governing information flows and personal data flows. So that's like the subject of my presentation. So an increasingly important role of online platforms in protecting and also harming data privacies in today's digital economy. And we have had already mentioned revelations about Cambridge Analytica and really about the ways in which audience platforms like Facebook provide access in various forms and like configurations to data-driven apps and services. And that can, the type of controls and settings that allow for the data access to take place are like heavily debated, of course, at the moment, because like it's been quite obvious that some of those things can go wrong. So then a recent development here in Europe are the court cases about responsibility, the controller concept. So in these networked service systems, the question is who is responsible for which data processing operations? And that, if you start looking at the core legal provisions of the GDPR, but also of the Directive, these cases are decided under the Directive's rules, is actually a super complicated and interesting problem to resolve. You know, in what situations is there joint responsibility, and how are they actually going to divide actual responsibility for specific rights and obligations under the GDPR to particular controllers, joint controllers in the ecosystem. Finally, and this is also because of the work that I've been doing in this space, it's really that you see ecosystem providers, platform providers emerge as quite powerful governors of privacy conditions and also the conditions for data-driven services. Under what conditions do they get access to the environment? Under what conditions can you get your app onto people's phones? You know. So then that brings me to thinking about what are these emerging roles of platforms in privacy governance. You know, so first of all, governing access to data. You know, audience platforms have a variety of ways in which data can become available to business users. Design of relevant interfaces and privacy mechanisms, establishing policy and technical standards. This is requirements related to privacy policies or specific types of data, you know, that you see also in the app store context. There's like a requirement to have a privacy policy, you know, if you're handling personal data, but also maybe specific requirements for what you're supposed to do if you're handling specific types of data that are becoming available through APIs on mobile phones. I think also a very interesting one is coordinating responsibility for privacy issues between platform users and the platform. So that really also relates to what you see now emerging as a requirement in these joint controllership case law. You know, that is really a role that the platform can start to take. It's like, this is your responsibility, this is my responsibility, and really dividing up responsibilities so that privacy data protection is effectuated in larger ecosystems. And then finally, direct and indirect enforcement of a platform's data privacy standards on relevant players, such as developers, apps, and third-party libraries. So you really see this kind of, through a whole range of particular governance functions, platforms emerging as very powerful shapers of privacy, the enjoyment of privacy or not in relevant ecosystems. So higher level functions I think are also interesting to look at. So there, I'm really interested in the way that platforms can play this role in translating different international, like maybe the better word here is jurisdictional regulatory requirements into platform policies. Since they, in many ways, maybe take a role that is facilitating compliance for a broader ecosystem, and it's not a question of directly having to comply or having direct obligations in many ways. They can also have some flexibility in the choices they make, to what extent they facilitate, and how they do that, and developing the tools and their policy practices in ways that can facilitate compliance across a whole range of different jurisdictions. And that is something that you can see also in the smartphone context, in the way that operating systems are designed, the APIs are providing access to data under various conditions, and the policies for the app stores. I think then that is like, so that connects to this facilitating compliance, the second bullet. But then also I think a clear role to help provide transparency into the functioning of the relevant ecosystems. You know, that's really having a pretty good overview of a much larger set of information flows that they're maybe not directly responsible for, but they definitely have an interest in observing, policing, and monitoring. And that puts platforms also, of course, in a position to be able to engage in discussions about the state of data protection. And then finally, striking a balance, this is like the higher level thing, between ensuring the respect for data privacy in data-driven environments on the one hand, and the optimization of the value and business opportunities connected to the platform and the underlying data for users of the platform on the other hand. So I think that's also where things can start to get very interesting. Maybe just as a final remark, I'm involved in this European Commission Observatory for the Platform Economy. It is kind of tied to the regulation on business-to-platform, fairness in business-to-platform relations. And what you hear there is that there are these situations where a platform is going to act restrictively with respect to a particular business user, and the motivation for that restriction is going to be like privacy. You know, so you really see that it's actually actively also being used to shape differential treatment. You know, it's like creates differential treatment between different business users without that really being clear that the platform has to do that. You know, and that really creates a situation where, like from the part of the Commission that is worried about fairness in this business-to-platform relations, you know, they're like confronted with the fact there may be good regulatory or policy reasons for these platforms to take an active role, but that sometimes platforms may take this very active role in ways that are maybe not fair from a business perspective. So I think with that I want to finish. Like, there's a bunch of papers that are relevant to my presentation. I just listed them here. Some work on mobile privacy and apps. And then finally there's this working paper. A new version is going to come online pretty soon about this responsibility for data protection in a networked world. Thank you.
Excellent. So I have a legal question and a technical question that I will address to the panel, and then I will turn to the audience for your questions for these experts. I think we've covered a wide array from legal to technical. So I'll start with the legal for Gabriela and Olivier. The question that occurs to me as you map out the legal landscape here is that there is a difference between process issues involved in data portability and substance issues, the substance of what must be ported or transferred. So the legal question is, does a controller who receives a request to transfer data have the right to object to the form or the process requested? So I will comply with your request, but only if you improve your security standards, other controller, or I will comply with this request, but only if you make it using the data transfer project described by Babak.
Thank you very much, Stacey. I can take it first, say a couple of words, and then I will give the floor to Olivier. I think the first view of it, a controller cannot refuse portability on the grounds of not having, of the receiving entity not having sufficient security protections. At the first look of it, I have to confess I have not been thinking about this deeply, but to my mind, it will be a bit difficult to see immediately this being on the list of restrictions under Article 23 in the GDPR. Of course, there is one exception there that talks about the rights and freedoms of others that you can base your restriction to the rights of the data subject on. But then, there should be an entire thought process behind that, and the rights of freedoms of whom? Can we talk about the rights of even legal persons, like processors, or? But again, on the first look at it, I would not immediately see a restriction there. Yeah, maybe you.
Yes, indeed, security is one of the key concern. Obviously, you should not use security concern as an excuse for not porting the data. But of course, the data controller, so the organization who has the data of the individual in the first place, need to take all measures, and this is the accountability of the data controller, that the data which are ported in a way which is secure, and that it reaches the destination, the receiving end, as you said, in a secure way. But the initial data controller, the starting point, is not responsible for the security of the endpoint in a way. So it's for also the responsibility of the individual when it has to port the data to, let's say, to another organization, basically to choose an organization which is, let's say, meeting the criteria, and it's the responsibility of the receiving end to comply with the GDPR. And you might have, indeed, initiative involving several the data controllers who will agree between themselves on the most secure way. And then when the data subject comes to, let's say, an organization and say, I want my data to be ported to this other organization, then of course, the data controller will be able to say, I advise you strongly to use this method because this is a safe method. But it goes in a way a bit further, maybe, because if I want to, I have a large set of data in the first, with the first organization, the initial organization, and I port this data to another organization for a certain purpose. Then the receiving end maybe will have too many data for this purpose. And it's a responsibility of the receiving end to delete this data, because in order to keep this data, you need, under the GDPR, of course, to apply the purposes, the principle of purpose limitation. So it might be that all the data which are transmitted to the second organization is not, let's say, appropriate for the purpose which is the purpose for which the individual is transferring this data. So we have to keep in mind that at each stage, both the initial data controller, the receiving end, have to apply all principles of the GDPR, including the principle of transparency, the principle of lawfulness of processing. Do I have a legal base to process this data? The principle of data minimization, of the purpose, etc. So, and this is why the link that was made with Cambridge Analytica and Facebook is not, I would say, not so obvious, the link with data portability, because in the case of Cambridge Analytica, what we had, the problem was that there was an unlawful processing of personal data. There was no legal base to process data of a number of people, the friends of the people who had given consent. Then there was a transmission of data which was not supported by legislation, and there was not the application of transparency rules in Cambridge Analytica. So it was not really a portability issue. There was nobody who said, please port my data to this controller. It was people sharing data between themselves without a number, the individuals being aware. Thank you.
Joris, I would love to get your thoughts quickly. Could we have a show of hands as to who will have a question? So I have roughly an idea. Okay, great.
Yes, maybe just very quickly. I think so. One thing is like this GDPR is great, and it provides like a baseline for like the handling of personal data. You know, but I think it's also clear that you can imagine many different services, and specifically also because data portability has this kind of connection to provided content, and this is like, it's almost like related to stuff that we think more in terms of intellectual property. So actually a lot of things, what is extremely relevant is what are the different licensing conditions, you know, with respect to this different content. And if you start porting, you know, between different services with different licensing conditions, you know, you can create quite complicated situations. So that's, I really like the point that Babak was making about policy portability. You know, what is this way in which this can be done in a meaningful way without generating really strange situations for users? I think it's a very relevant question. So it's like, really GDPR is there and it is a baseline and that is good, but there could be a lot of stuff on top of that in the way that this relationship between users and services are being shaped. So then maybe quickly a second point, if data portability is used in ways that data is being ported from services that are GDPR compliant and secure to services that are not, and maybe you can receive a bit of a premium because it's probably cheaper to do it in the service in the second instance. You know, you can imagine there's quite a strong incentive for DPAs to get involved in that. You know, that is not a good situation when there's that type of a market activity and information flow in the market. It's like, and imagine DPAs would be very interested to investigate.
Babak, I know you've done a lot of thought about this too, so welcome for you to chime in. And I have another question for you that we were discussing earlier, which is so the examples that you gave in the data transfer project largely involved companies that hold account level data. So individuals who have signed up for an account with an email address and some level of what in the United States we might typically think of as more traditional identifying information. But how can platforms perhaps facilitate when they do not have that kind of information, but may only have pseudonymous information, which is not tied to a name or an email address, but might include a mobile advertising identifier or a MAC address or something of this nature, which is clearly there's consensus at the EDPB, IICO that this is included in data portability, but may be difficult to validate that the ID that you have belongs to the person requesting?
Well, that's a good question. I mean, first, it's given the community-driven nature of this project. First, there has to be a valid user benefiting scenario, right? So somebody has to think of a case where the transfer of, say, to de-identified information to a certain degree would be useful. We haven't envisioned such scenario yet. Not that it doesn't exist, but we've been busy with more obvious cases. But as Olivier mentioned, data portability is mainly about data that the user has provided, and to some degree, the data that has been captured about the way the service was used. So in that case, yes, IP address qualifies. Browsing history, for example, or let's say your online video watching history and all that. This is all part of the capture data that is included. But when it comes to de-identified data, I mean, it could be included, but from a technical perspective, it is possible. It's just that we haven't found a community-driven need for it yet. Nobody has come up with a cool scenario that, hey, let's get this transfer this data. But again, if there was a scenario like that, transfer of partially de-identified data is definitely in the engineering realm of possibility. It's just that, is it useful?
Why don't we take the first three questions and then we'll direct them to the panel. We've got, yes, sir. Oh, there's a microphone up front. Yes.
Hi, Lucas Ilves from the Lisbon Council, a think tank here in Brussels. So, I mean, portability, we've been speaking about it here in terms of the GDPR drivers, but it can serve a lot of other policy goals, competition, empowerment, et cetera. And you've got sectoral regulators who already have acted on that, like in PSD2. You've got hard measures, and you've got soft measures that might be like building the ecosystems and defining the data formats. I guess a question that is perhaps particular to Babak, since you've been building this kind of ecosystem, but also to others, what are the drivers for the economic participants to want to engage in this data portability and do the work above and beyond just compliance to put in place the infrastructure, the formats, to do what you mentioned is very costly work on a voluntary basis? Because, I mean, in some places, financial sector, ultimately regulators came in and said, we're going to require this, and there's a public interest. But even where you don't have that additional impetus, what are the reasons you might want to actually contribute to that and make portability easier?
I think, Joris, you might be able to speak to that too. Let's take a couple more and we'll answer them.
Hello. I was wondering whether any of you have considered how long is it going to be until, also with regard to data portability, we will see special offers like the kind that we have when you port numbers, telephone numbers. And it's not just that. I'm actually considering whether this could turn into an anti-competitive behavior, because while data portability only concerns the data that was actively provided and the data that was observed by the data subject, we all know that it's not that difficult once you have that to also derive data and do whatever you want with it. basically data is the new oil, so I think, actually I know for sure that a lot of players are interested to find a way to convince people to give them data, including by paying for it, because you're actually paying a dime and receiving a much higher value when you actually gain traction from it. So I guess this potential anti-competitive behavior is what I'm concerned about.
And I think the question is, how long until we see specific examples of this? Yes, good.
Hello, I have a question related to this. I feel data portability is very limited in its scope because it does not include inferred data, and this would be the most interesting part because all the other data you either provided yourself so you know it, or you can copy paste it. So what is the sense of separating portability of access, and maybe would it make sense if in Europe we go like the Californians did and combine them again and make maybe a more powerful right?
That one I think is for you, Olivier.
Well, I think we have to see from where does the right to portability start from. The idea was that, for instance, you use a social network, you have uploaded all your photos, you have all your friends, etc. So, and this you don't want to lose when you use when you go to another service. Then the same for your bank account. You have all your transactions, etc. Now let's assume that the bank, in order to evaluate your creditworthiness, has built a profile of you. They have done that according to their own algorithm. They have basically had their own internal system for that, which is their own system. Then, of course, when you have you want to know basically what the data controller has on you, this is right of access. You have an information about all the type of data that they have, that this data controller has on you. But you will not be able, it will not really be pertinent in a way to have the profile that the bank has built on you with their own algorithm to be transferred to another bank. First of all, because this profile is built in a certain way. Second, this is the added value of the bank. This is where they invest money, basically. So to have this information, which is not the one provided by you, but this is inferred information from your personal data, but this is not the one you have provided, the one which is observed, then would completely deprived, in a way, let's say, would deprive the bank in this case, although I don't specifically like banks as such, but especially on Friday afternoon. But honestly, this would deprive them from the added value they have built. So, and this is, then the question also you have to think is, what is useful for, as an individual, and this goes beyond, in a way, maybe the right of portability under the GDPR. If you want to port your telecommunication data, you're interested about how many times you call abroad, the length of your telecommunication, maybe where you were when you when you called, etc. You are not necessarily interested to know all the technicalities about the mast which has been used to transfer the signal and the masses of data which are around. What are you going to do with that? Probably you cannot even exploit, and the usable data will be lost into this wealth of data that you will be receiving. So you have indeed, this is why it's focused on this data provided by, the data which can be observed, but not all the data which in fact relates to this activity in a broad sense. As I said, it will be a case-by-case evaluation because it's not easy for every sector, to fix exactly the limit. There might be in the future, I don't know, case in the court where there will be a clarification. But I think we have to be also reasonable in the sense that we should not impair this right. We should not simply say you can port your name because you put your name basically in the bank account and all the rest is not covered. We have to see the substance also of the right. I think this is why this evaluation and this global reflection also between industrial federations, between companies, in order to make this right really meaningful is important.
Briefly, Gabriela, do you want to add anything to that before we go to the next question?
Yes, briefly. I completely see the limitations of data portability, and I know that inferred data has been ruled out even by the EDPB as being subject to portability, and it's the letter of the law, and yes, there is room for interpretation, but the letter of the law is the letter of the law. However, if we go to the theory of informational self-determination, the theory of data protection, and think a bit deeper about these things, and if we think of some sort of reflected digital personality of a person, and if we want to give to the individual control over their over how the world perceives the person, perhaps at one point in the future we can think of interpreting this right in a broader manner. And one last very brief point on CCPA, I just realized that on Laura's point, actually the definition of personal information in the CCPA specifically covers inferred data. So then if you obtain access to inferred data, and it has to be in an interoperable format if you do obtain it, and it's not limited by any other of the restrictions, even inferred data would be covered by that type of limited portability, because that portability is not from controller to controller. That portability is strictly limited from controller to individual, and then the individual can, do whatever.
Bring it somewhere else, yeah. I want to get to Lucas. I think your question was very similar to the question we had up in the front, really, which is about economic incentives for anti-competitive behavior, right? And when are we going to start seeing it, and what are the underlying incentives involved? So I think
Positive incentives.
Yeah, not only anti-competitive.
positive incentives to engage. Yeah, sure. Excellent. Excellent, excellent. Babak and Joris, I think.
So there are, you can envision scenarios where, having gone beyond the obvious data portability scenarios, if the community were to come together and this were to catch on, it's easy to think of scenarios where new business models, new applications, new ingenious ways of using data could come about, that could be helped with the facilitation of ease of data portability, especially direct transfer of data. For example, I mean, I'm just one shot in the dark. When I was younger, I used to drive fast, and I used to get a lot of speeding tickets. Now I'm older and wiser and maybe slower. It would be nice if I could call my cell phone company and say, hey, now that I'm older and drive slowly and all that, I want to be able to get that data, my geolocation data that I know you have, because I want to turn around and give it to my car insurance company and say, hey, give me 20% discount. I'm older now. See, I haven't got a ticket for 20 years and so forth. And here's my average speed per day or whatever. So and then somebody could build a startup that facilitates that and creates a score and shares it with the insurance company. So it is easy to imagine that if data were to be exchanged efficiently, that there are going to be new business models and opportunities for startups or just scenarios where they can be profited from or monetized, and new services could be offered. And that would be definitely a lot of economic incentive.
Geolocation, I think, is a great example, because there's so much existing economic incentives to collect it, and because raw geolocation over time can lead to such sensitive inferences, right? For a wide variety of economic uses, and often platforms are well situated to collect it, right? So, Joris, you want to speak to that example and other examples to these questions?
Mm-hmm. Yeah, so I also sometimes have to, when we imagine these types of business models and really put people in in charge and like allow them to like reap the benefits of having data, and maybe even competing with their data in the marketplace, I have to think of like, I mean, there's been a whole series of these types of like projects with a lot of enthusiasm around this. I remember also like Project VRM, I don't know if it still exists, like vendor relationship management, that had that type of perspective. I think like there are some, maybe one point about like this point of how these incentives are working out in practice. I think actually it's very hard to extract the value that is there in the service, like related to the data, but like by just taking the data. I think that's just like, and in some way that related to the data access question is like there's some stuff that is not covered by data portability, and you end up maybe just not getting the whole thing that is extremely valuable. But I think really data is like a large chunk of the data, and the value of the data is really directly connected to the way that services are being managed. You know, it's this constant way in which data flows also allow companies to evaluate how well they're performing and optimizing the way that they're offering a particular kind of functionality. You know, and so there are some really key areas where you can take data that has separately also value and take it out and port it to somewhere else. And we can think of loyalty program type of situations, or you can think about many situations. But I think like in a very broad sense, and data portability in the GDPR is very broad. Maybe the imagination is a bit too broad too in how all of this can provide value. So I really think that like I'm struggling with really following the intuition that you can really take the full value out and then porting it over. And maybe also on top of that, there are a lot of situations where you're just going to plug yourself into an environment that already allows you to get a lot of data. So now, like smartphone platforms are a great example. You know, you have a smartphone app, you can start like grabbing data from people like on the basis of all the APIs that are there and the sensors, and maybe then there's some data with data portability you can use to kind of like kickstart your operations, and that could be very interesting. But I don't think we have to be, I don't think we should be too like projecting too much value on this data portability, right?
But just to clarify a bit my question, I'm not talking about extracting value that's already there. I'm talking about generating your own value without having to work for obtaining the data, because there is considerable investment that goes to the stage of just obtaining the data. When you can get that through portability, incentivized, as I said, you don't have to worry about that. You just worry about generating your own value, which can have nothing to do with the original source of the data, because you can do something completely different after you get the data. And that's why I was saying the new Cambridge Analytica, because it would be an incentive given to people to port their data to a service like that, which would use it as they deem fit, legally or not. I'm not debating that right now. The thing is that you can generate a different value after you receive the data compared to what it used to be. I wouldn't equal the two at all. And that is actually where I see a potential big problem.
I think this is an extremely good point, and since we have limited time, I think we have time for one more question, and I'm going to ask the panel to close with, in one or two sentences, the most interesting hypothetical use case that you're looking at in the next 5 years that will present legal or technical or both challenges. So, yes. Yeah.
Right. My name is Valentina Pavel. I'm a Mozilla Fellow focusing on data governance and concentration of corporate power. I have a couple of points that I'd like to make regarding this inferred data. I would see it as you can now send an access to data request to the ad tech industry and receive your ad tech related profile. I don't see why this shouldn't be the case for banks or other service providers, and it should be covered by the same data portability What I would not like to see is first, I would need to be smart and issue an access to data request to the service, and then do another data portability request and be super sure, 100% sure that it's exactly the same data that they're providing. Also, I would argue that data portability is a very useful tool for users that do not want their information exploited and harvested by big companies, and they just want to port it to a really honest service that they trust and they want to go there. So I would say data portability would challenge the concentration of power that we see nowadays.
Excellent, thank you. Thank you. We're at 3:30, so panelists, in one sentence, what are you looking at the next 5 years, most interesting use case? Olivier, start at the end.
Why am I starting?
So that it gets back to me.
Oh, well, in the next 5 years, you know, as a good bureaucrats from the Commission, as a good bureaucrats, I think that what we are doing is basically monitoring what other people are doing. Whether indeed, I mean, we see that people are able to exercise in practical terms these rights and other rights. So one of the tools that we will use is a number of complaints that we will see reaching the data protection authorities. Also, what we will monitor closely is, for instance, the development of code of conducts, which is a tool under the GDPR. We know that some of them are in the making, and this is a good framework, for instance, to have part of the industry agreeing on how they will implement this right to portability. So this is what we are going to look at in the next years.
Codes of conduct as a prediction, I like it. Yes. Babak.
I think we all have looked at GDPR, and we have privacy fever, and that's all good and needs to be taken care of. But I think the next 2 to 5 years, having taken care of personal data, the industry and the community will be thinking about organizational data. Now, we have a brand new regulation on free flow of non-personal data. And when I see a negative to be a negative for a negative term defined at the centerpiece of a regulation, I see a problem, because there's really no definition for it. And the data sets are all personal and non-personal and professional and business are all mixed. So I think the issue of co-controlling and sharing all that will be the core, I'm predicting that it will be the core agenda the next 2 to 5 years.
Excellent. And Gabriela, and yours, maybe we'll keep it to just words a sentence.
Yeah, I will just, in the next 5 years, I will think a lot whether there is any link between data portability and being able to port only on specifically defined markets, you know, because we have competition implications, or if there's anything out there in connection with defined markets and portability.
Excellent.
Yeah, so maybe this is the maybe resolution of this gap between data portability and data access rights. I think that's one for the coming decade.
Excellent. Please stick around, come see us. Thank you so much, Thomas, for this panel, and thank you all for coming.